If you own an AR-15 in Illinois, or a standard capacity magazine, or any of the more than 1,000 firearms that the state banned in 2023, here is exactly where your case stands right now. A federal judge already ruled in your favor after a full 4-day trial. The Trump administration's Department of Justice called the Illinois ban flatly unconstitutional and personally argued against it in federal court. And yet the ban is still in effect. The guns you legally owned before January 2023 are still restricted, and the law that took them off the sales floor is still being enforced. How is that possible? And more importantly, when does it end? That is exactly what this video is going to answer. Are you subscribed? Because the PICA case is one of the most consequential Second Amendment battles in the country right now, and I am going to break down every development in a way that actually makes sense. Hit subscribe right now because this case is moving fast and you need to stay informed. Let me start from the very beginning so you understand exactly what PICA is, why it matters far beyond Illinois, and why this case could determine whether assault weapon bans survive in America or fall completely. On January 10, 2023, Illinois Governor J.B. Pritzker signed House Bill 5741 into law. The official name is the Protect Illinois Communities Act. Gun owners call it PICA. And within days of it being signed, legal challenges began flying from every direction. PICA did several things. First, it banned the sale, manufacture, delivery, and purchase of so-called assault weapons going forward. The list of banned firearms is extraordinary. Over 1,000 previously legal firearms suddenly became illegal to sell or buy. This includes AR-15 style rifles, AK pattern rifles, and dozens of other semi-automatic firearms that millions of law-abiding Americans own. Second, PICA banned large-capacity magazines. For long guns like rifles and shotguns, any magazine holding more than 10 rounds is banned. For handguns, any magazine holding more than 15 rounds is banned. These are standard magazines that come factory installed in many common firearms. Third, PICA included a possession grandfathering provision with strings attached. People who already owned banned firearms and magazines before the law took effect could keep them, but only if they registered with the Illinois State Police by a specific deadline. The registration requirement itself became a source of enormous controversy. Fourth, PICA included various other provisions restricting switches, accessories, and features on semi-automatic firearms. The reaction from the gun rights community in Illinois was immediate. Within days, multiple lawsuits were filed challenging PICA as an unconstitutional violation of the Second Amendment. These cases were filed in federal courts throughout Illinois, and they were filed at exactly the right moment in constitutional history. Let me explain why timing matters so much here. In June 2022, just months before PICA was enacted, the Supreme Court issued its landmark decision in New York State Rifle and Pistol Association versus Bruen. Bruen completely rewrote the rules for evaluating gun control laws under the Second Amendment. Before Bruen, courts used a balancing test that weighed the government's interest in public safety against the burden on gun rights. Under that test, courts routinely upheld gun control laws by deferring to government claims about public safety. Bruen threw that test out entirely. After Bruen, courts must ask whether a challenged gun regulation is consistent with the historical tradition of firearm regulation in America at the founding and at the time of the 14th Amendment's ratification. If the government cannot show a historical analog, the law fails. Full stop. No balancing. No deference to public safety arguments. Just history. PICA was enacted just 6 months after Bruen. Illinois knew Bruen was the new standard when it passed the law. But it passed PICA anyway, essentially daring the courts to apply Bruen and strike it down. Gun rights advocates accepted that dare immediately. If you're finding this helpful, subscribe right now so you don't miss the 7th Circuit ruling when it drops. Because it is going to come out of nowhere, and when it does, you need to understand immediately what it means. Hit subscribe. Now let me walk you through the litigation timeline because it is complicated and confusing and most people only know bits and pieces of it. The primary case is now consolidated at the 7th Circuit Court of Appeals under the name Barnett v. Raoul. The Barnett case was one of the first filed and has become the lead case in the challenge to PICA. It was filed by plaintiffs backed by the National Rifle Association. A companion case called Beavis v. City of Naperville was filed by the Firearms Policy Coalition and is also part of the consolidated proceedings. A third major case, Harrell v. Raoul, was filed separately by the FPC and also challenges PICA directly. All of these cases have been consolidated for purposes of the Seventh Circuit appeal. Here is the timeline in order. January 2023, PICA is signed into law. Almost immediately, multiple lawsuits are filed in federal district courts in Illinois. April 28, 2023, Federal District Court Judge Stephen McGlynn issues a preliminary injunction against PICA in the Barnett case. Judge McGlynn found that the plaintiffs were likely to succeed on the merits, meaning they had a strong enough case that the law should be paused while litigation continues. That was a huge early win, but it didn't last long. On November 3, 2023, a three-judge panel of the Seventh Circuit reversed Judge McGlynn's preliminary injunction. The Seventh Circuit panel concluded that PICA likely does not violate the Second Amendment. The ban went back into full effect. The gun rights plaintiffs kept fighting. The case went back to the district court for full merits proceedings. Over the following year, extensive briefing was conducted, expert witnesses were prepared, and ultimately a full 4-day bench trial was held before Judge McGlynn. Then came the most significant development yet in the entire case. On November 8, 2024, after sitting through 4 days of trial testimony and reviewing mountains of historical evidence, Judge McGlynn issued a permanent injunction against PICA. Not a preliminary injunction based on likelihood of success. A permanent injunction based on a full merits determination. After a complete trial, Judge McGlynn concluded that PICA is unconstitutional under the Second Amendment and the Bruin framework. The state of Illinois could not enforce its assault weapon ban. PICA was dead. For about a month. On December 5, 2024, the Seventh Circuit Court of Appeals stayed Judge McGlynn's permanent injunction. A stay pauses a lower court ruling while an appeal is pending. So even though a federal judge found PICA unconstitutional after a full trial, the Seventh Circuit put that ruling on hold. PICA went back into effect, and as of today in June 2026, PICA is still in effect. The sale and transfer of the restricted firearms and magazines are still prohibited in Illinois. That is the frustrating reality that Illinois gun owners are living with right now. Quick legal note. This is educational information, not legal advice. Gun laws are changing rapidly and every situation is different. Always consult with a qualified attorney about your specific circumstances. Now let me tell you about the development that changed everything. The development that gun rights advocates never saw coming even a year ago. On June 13, 2025, the United States Department of Justice filed an amicus brief in the Seventh Circuit supporting the challenge to PICA. Amicus means friend of the court. It is a brief filed by someone who is not a party to the case but has a strong interest in the outcome. And when the federal government's Department of Justice files an amicus brief, judges pay attention. This is not a law student organization or a think tank. This is the full weight of the federal government coming into a case and telling the court what the law is. The DOJ's brief was 34 pages long. It called PICA flatly unconstitutional. Let me say that again. The United States Department of Justice, in a formal legal brief filed in federal court, called Illinois' assault weapon ban flatly unconstitutional. The brief argued that because PICA bans arms that are commonly possessed for lawful purposes, including AR-style rifles and standard capacity magazines, it violates the Second Amendment under the Supreme Court's test for Second Amendment challenges. The brief also told the Seventh Circuit directly that it had misapplied the Bruin standard when it reversed the first preliminary injunction. It urged the Seventh Circuit to affirm Judge McGlynn's permanent injunction. The significance of this cannot be overstated. Under the previous Biden administration, the DOJ would have been on the other side of this case. It would have been defending Illinois' right to ban assault weapons. Now the DOJ has completely flipped. The federal government is arguing that assault weapon bans violate the Second Amendment. This is the most dramatic pro-gun shift by the executive branch in modern American history. FPC President Brandon Combs said it plainly after the brief was filed. He said the DOJ brief underscores their argument that the Seventh Circuit must affirm the district court victory under binding Supreme Court precedent. But the DOJ didn't stop at filing a brief. On September 22, 2025, oral argument was held before the Seventh Circuit in the consolidated PICA cases. And the DOJ did something remarkable. The plaintiffs gave 5 minutes of their oral argument time to the DOJ's attorney. That attorney was Harmeet Dillon, the Assistant Attorney General for Civil Rights. Harmeet Dillon personally stood up in the Seventh Circuit and argued that Illinois' ban on AR-15s and standard capacity magazines violates the Second Amendment. This is the first time in American history that the Federal Department of Justice has argued against a state assault weapon ban in federal court at the appellate level. That hearing on September 22, 2025 was genuinely historic. Hey, 73% of people watching right now are not subscribed. If you care about the Second Amendment and you want to know the moment the Seventh Circuit issues its ruling, this is the channel you need to be subscribed to. I will have analysis up within hours of any ruling. Hit subscribe right now. So now the question everyone is asking is simple. What happens next? As of June 2026, the Seventh Circuit has still not issued its ruling. Oral argument was held September 22, 2025. That means the court has been sitting on this decision for 9 months. That is a long time, but not unheard of for a complex constitutional case with significant national implications. The court is almost certainly aware that its ruling could set the precedent for assault weapon bans not just in Illinois but across the entire country. Maryland, California, New York, New Jersey, Connecticut, Hawaii, Massachusetts, and Colorado all have some form of assault weapon ban. Whatever the Seventh Circuit decides will be cited by every court handling challenges to those bans. Let me explain what the Seventh Circuit is weighing. The central question is whether AR-15s and standard capacity magazines are protected by the Second Amendment under the Bruin framework. That framework has 2 steps. First, are these weapons covered by the plain text of the Second Amendment? Second, is there a historical tradition of regulation analogous to the modern ban? On the first question, the plaintiffs and the DOJ have an overwhelming case. AR-15 style rifles are the most popular rifle category in America. There are an estimated 24 million or more in civilian hands. They are used for hunting, home defense, sport shooting, and recreational use by millions of law-abiding Americans every day. Under the Bruin test and the Heller test before it, weapons in common use by law-abiding citizens for lawful purposes are presumptively protected. The AR-15 is beyond any reasonable dispute in common use for lawful purposes. On the second question, the state of Illinois faces a nearly impossible task. It must show that there is a historical tradition in America of banning the most commonly owned category of rifle. That tradition simply does not exist. In 1791, when the Second Amendment was ratified, and in 1868, when the 14th Amendment was ratified and incorporated the Second Amendment against the states, there were no laws banning the most popular rifles of the era. The historical evidence presented at Judge McGlynn's 4-day trial was extensive, and Judge McGlynn concluded after hearing all of it that Illinois has no adequate historical analog for banning AR-15 style rifles and standard capacity magazines. The DOJ came to the same conclusion in its brief. Now let me talk about the SCOTUS dimension of this case because the Supreme Court is deeply involved even though it has not yet taken up PICA directly. The Supreme Court has been relisting a closely related case called Viramontes v. Cook County. Relisting means the justices are considering whether to take the case but keep putting off the decision. The Supreme Court's conference schedule shows Viramontes being relisted multiple times, which usually signals that the justices are seriously debating whether to grant certiorari and hear the case. If the Supreme Court grants cert in Viramontes or a similar assault weapon ban case, everything changes. A Supreme Court ruling on whether assault weapon bans are constitutional would be binding nationwide. Every state ban would either be upheld or struck down depending on how the court rules. There is a strong argument that the Supreme Court is waiting for the Seventh Circuit to rule in Barnett before deciding whether to take up any of the related assault weapon ban cases. The court may want a circuit split to develop, meaning it may want to see different circuits reach different conclusions before stepping in to resolve the question. If the Seventh Circuit strikes down PICA, you would have the Ninth Circuit's decision upholding California's assault weapon ban and the Seventh Circuit striking down Illinois' ban. That circuit split would create enormous pressure for the Supreme Court to take the issue and resolve it definitively. If the Seventh Circuit upholds PICA, the case may head directly to the Supreme Court on a petition for certiorari from the gun rights plaintiffs. Let me also tell you about 2 other major developments that have occurred since the September 2025 oral argument that directly bear on the Seventh Circuit's pending decision. First, the Fifth Circuit Court of Appeals in a case called United States v. Wilson denied rehearing en banc in a machine gun ban case. Now you might think, a machine gun case? What does that have to do with AR-15 bans? The answer is everything. The Wilson case dealt with the federal ban on machine guns under the Bruin framework. The Fifth Circuit denied rehearing, which means the panel decision stands. But what's significant is not the outcome but the opinions. Multiple federal judges on the Fifth Circuit wrote separate opinions questioning the constitutional basis for categorical firearm bans under Bruin. These opinions signal that serious constitutional questions are percolating through the federal courts about whether any categorical ban on an entire class of firearms can survive Bruin. The Seventh Circuit judges are reading those opinions. The constitutional arguments about categorical bans apply directly to PICA. Second, the Trump administration escalated its campaign against state assault weapon bans in the months following the oral argument. The DOJ filed federal lawsuits directly against Colorado and the District of Columbia for their assault weapon bans. The argument in those lawsuits mirrors exactly what the DOJ argued against PICA. Common arms in lawful use cannot be banned under the Second Amendment. These new federal lawsuits create a broader battlefront. If DOJ wins in any of those federal suits, or if any court issues a ruling that assault weapon bans are categorically unconstitutional, those decisions will be cited in support of the Barnett challenge in the Seventh Circuit. Let me now be very specific about what the different possible outcomes mean for Illinois gun owners. Scenario 1, the Seventh Circuit strikes down PICA. This is what Judge McGlynn's permanent injunction said should happen. If the Seventh Circuit agrees with the district court, the stay of the permanent injunction is lifted. PICA immediately becomes unenforceable. AR-15 sales can resume in Illinois. Standard capacity magazines can be sold again. Dealers who stopped selling these items can put them back on shelves. Gun owners who want to buy AR-15S or standard capacity magazines can do so. Illinois would likely petition the Supreme Court for certiorari to stay the ruling and seek reversal. They might succeed in getting another stay. But a Seventh Circuit ruling striking down PICA would be an enormous victory and would create the circuit split that makes Supreme Court review likely. Scenario 2. The Seventh Circuit upholds PICA. This would reverse Judge McGlynn's permanent injunction. PICA would be fully sustained by the appellate court. Illinois's assault weapon ban would continue in full force. The gun rights plaintiffs would petition the Supreme Court for certiorari. Given the enormous stakes and the fact that this is exactly the kind of unresolved constitutional question the Supreme Court takes up, there is a strong probability that the court would take the case if the Seventh Circuit upholds the ban. But the timeline for Supreme Court review is measured in years, not months. It could be 2027 or 2028 before the Supreme Court issues a final ruling. Scenario 3. The Seventh Circuit issues a narrow ruling on procedural or technical grounds without fully resolving the constitutional question. This is the worst outcome for everyone because it would prolong the uncertainty without giving either side a clear answer. Courts sometimes do this to avoid difficult constitutional questions. If the Seventh Circuit does this, expect immediate criticism from both sides and likely parallel petitions to the Supreme Court. Now let me talk about what this means for Illinois gun owners right now, today. The law is clear on one thing. PICA is currently in effect. The stay of the permanent injunction means that the ban on selling and transferring restricted firearms and magazines is still enforceable by the state of Illinois. Do not assume that because a federal judge found PICA unconstitutional, you can act as if it is already struck down. It is not. The injunction is stayed. The law is in effect. You need to comply with PICA as written until a court order says otherwise. What this means practically is that dealers in Illinois cannot legally sell AR-15 style rifles or standard capacity magazines to the general public. Individuals cannot legally buy these items in Illinois. Existing owners who completed the registration process can retain their grandfathered weapons. Those who did not register by the deadline face a more complex legal situation that varies depending on the specific weapon and their specific circumstances. If you are in this category, consult an attorney. What you can do right now is stay informed, support the organizations litigating this case, and make sure you understand exactly what is and is not permitted in your specific situation. The NRA, the Firearms Policy Coalition, the Illinois State Rifle Association, and the Second Amendment Foundation have all been active in this litigation. Their resources, their legal teams, and their advocacy are what has brought this case to the point where a federal judge issued a permanent injunction, and the DOJ is arguing on the same side. If you want this case to succeed, support those organizations. Let me also address the broader national significance of this case one more time. PICA is not just an Illinois case. What happens in Barnett versus Raoul will be cited in every assault weapon ban challenge in the country. There are active challenges to California's assault weapon ban. There are challenges to Maryland's ban. There are challenges to bans in Connecticut, New York, New Jersey, Hawaii, and Colorado. The DOJ is now suing Colorado and D.C. directly. All of these cases are waiting for guidance from appellate courts on how to apply Bruin to assault weapon bans. The Seventh Circuit's ruling in Barnett will provide that guidance for the Seventh Circuit and will be persuasive authority in other circuits as well. If the Seventh Circuit strikes down PICA, it will be the most powerful pro-Second Amendment appellate decision since Bruin itself. And if the Supreme Court ultimately takes this issue and rules that assault weapon bans are categorically unconstitutional under Bruin, that ruling would invalidate every state assault weapon ban in the country at once, every California AR-15 ban, every New York assault weapon restriction, every Maryland prohibition, all of it, gone in a single Supreme Court decision. That is what is ultimately at stake, and that is why this case matters to every gun owner in America, not just those in Illinois. Here is your action plan while you wait for the Seventh Circuit's ruling. First, know the current law. PICA is in effect. Comply with it until a court orders otherwise. Violating PICA while the stay is in place carries real criminal consequences, regardless of what you think the law should be. Second, follow the case closely. Subscribe to updates from NRAILA, Firearms Policy Coalition, and Illinois State Rifle Association. They will have immediate analysis when the ruling drops. Third, support the litigation organizations financially. These cases cost millions of dollars to litigate. Every donation helps keep the legal challenge going. Fourth, contact your Illinois state legislators. While the case is pending in court, legislative advocacy matters. Pushing for repeal or amendment of PICA through the legislative process is a parallel track to judicial relief. Fifth, if you have questions about how PICA specifically applies to your collection, your purchases, or your specific situation, consult a firearms attorney licensed in Illinois. The law has specific provisions that apply differently to different people and circumstances. Sixth, do not fall for misinformation. There are people online who say PICA is already struck down because of Judge McGlynn's permanent injunction. That is wrong. The injunction is stayed. PICA is in force. Do not make legal decisions based on inaccurate information about the status of this case. Seventh, when the Seventh Circuit rules, read the actual opinion, not just the headlines. The details will matter enormously. What standard the court applies, what language it uses, and what it says about future cases will all be critical to understanding what the ruling actually means. Let me leave you with the big picture. Illinois enacted PICA in January 2023 in the immediate aftermath of Bruin, essentially daring the courts to strike it down. A federal judge said it was unconstitutional after a full trial. The Trump DOJ called it flatly unconstitutional and argued against it in federal court for the first time in American history. And yet, the law is still in effect because the Seventh Circuit imposed a stay. The legal system moves slowly. That is frustrating. But the momentum in this case is unmistakably on the side of gun rights. You have a permanent injunction from a district court. You have the DOJ on your side. You have SCOTUS actively considering related cases. And you have a growing body of post-Bruin decisions around the country questioning categorical firearm bans of all kinds. This case is not over. It is actually just reaching its most critical moment. Subscribe now because I will have complete coverage and analysis the moment the Seventh Circuit issues its ruling. That ruling could come any day. It could come this week. And when it does, you do not want to be waiting for someone else to explain it to you. I will have it covered, broken down, and explained in plain English within hours. Hit subscribe right now. And if you know another Illinois gun owner who is following this case, share this video with them. They deserve to understand exactly where things stand and what comes next. This is educational content, not legal advice. For your specific situation, consult a qualified attorney. Stay informed and stay engaged, because this fight is not over yet.